Title 1, Offences Against the Person. Section 1, Intimidation. Title 1, Section 1, Intimidation, is a misdemeanor offense which replaced the former offense of criminal threats. It has 3 subsections, each explained within this episode. Take a moment to read through the legislation. This is exactly as the offense appears in the Penal Code. Basic offense definition. Intimidation is the act of communicating a threat of physical harm or violence against a person or their associates. The method of that communication is left deliberately vague and can include, but is not limited to, verbal, written, email, text message, phone call, etc. This offense has 2 alternative parts: intimidation of another, personal, and intimidation of another's associates, impersonal. For personal intimidation, the victim must be placed in a reasonable state of fear. For impersonal intimidation, this is not the case. Points to prove for personal intimidation. A person. This offense can only be committed by a person, not by a business. Communicates to another, the recipient of the communication, that they will physically harm or kill, to such other, i.e., this is a directed personal threat towards the recipient, placing such other in a reasonable state of fear for their own safety. The recipient does not need to be scared, but must believe it may actually happen. Points to prove for impersonal intimidation. A person. This offense can only be committed by a person, not by a business. Communicates. There does not need to be a specific recipient of this communication. It could be a tracebook status, for example. That they will physically harm or kill another person's, i.e., someone else's, not their own, close friends or relatives. There is no legal definition of close friends, so anyone personally known to the other person mentioned above is sufficient. The common sense definition of relatives applies. There is no necessity to prove a reasonable state of fear for impersonal intimidation. Someone simply saying, "I'm going to kill your family," in the street completes the offense of impersonal intimidation, whether or not the recipient of such threat has any belief it may be true. Important notes. There is some crossover between intimidation and assault, covered later. The main difference is the time between the threat and the potential for it to actually happen. Intimidation is intended to refer to potential violence sometime in the future, whereas assault is the threat of immediate potential violence. Investigative procedure. At an early stage, you should record the nature of the threat made. With an offense of this nature, a key part of the evidence is what the communication actually said, word for word. Make a note of this. It will need to be included in any subsequent arrest records or reports. Where possible, this should be recorded as direct speech rather than as hearsay. You will need to speak to the victim in the case of personal intimidation to determine whether or not they've been placed in a reasonable state of fear. It is not necessary for the victim to agree to press charges, simply for them to confirm that they were placed in a reasonable state of fear. Where possible, you should note the name of the victim and take a statement to be used in the arrest record or report. There is no need to speak to the victim in the case of impersonal intimidation. Once the communication has been witnessed and is deemed to communicate that they will physically harm or kill another's close friends or relatives, the offense is complete and the person can be charged. A key investigator action will be to determine the distance, both in terms of space and time, between the person communicating the threat and the recipient of such a threat. If the threat of violence is close range and immediate, assault may be more suitable. Administrative procedure. It is not required to file an arrest record or report for intimidation by default. If, however, the suspect is due to be admitted to San Andreas Correctional Facility, the arresting officer must include the direct quote of the suspect's threats and the victim's statement in the case of personal intimidation as explained in the investigative procedure. It may be advisable to file an arrest report in every case of intimidation, as the nature of the communication is central to the offense, so should be recorded for future review. Penal policy. Intimidation is a misdemeanor offense, so falls under officer discretion, covered later. There is no requirement to retain DNA for this offense. The offense has a sentence range of 15 to 25 minutes. In deciding the appropriate sentence, you may wish to consider the effect the threat has had on the victim, the extent to which it may have materialized, the steps taken by the suspect to carry out the threat, etc. If a warrant is issued for intimidation, it would be considered low risk.